Sorry about that, our video cut out, but we were discussing prior existing use as the third type of implied positive easement. We stated previously that, again, the requirement that there needs to be some sort of dominant and servient parcel, so more than two that were once unified by a single owner or person or entity, and there was some sort of conveyance that broke up that original single parcel into multiple parts. And before that conveyance that broke up the common ownership, part of that parcel was used for the benefit of another portion. Now, the third requirement that we have, I like to remember this as AOCP, that we've got requirements that this use must be apparent, it's got to be obvious, it has to be continuous, and it must be permanent. Now, the claimed easement is reasonably necessary to the enjoyment of the dominant parcel. So let's say if we had one portion here, and then we've had the dominant parcel might be the middle one, for example, and then the left and the right might have been the servient parcels. In order to enjoy that dominant parcel, you'd have to use the easement around the servient parcels, which is reasonably necessary, such as an example of a road going through the entirety of the parcels which were broken apart at conveyance. So again, apparent, obvious, continuous, and permanent, AOCP. Reasonably necessary. On an essay, we look for facts such as there's an alternative, but it would be more expensive compared to the cost of value of the property. We look for impracticality. Now we look for disrupt the business, any disruption of business. A longer proposed easement has been in use. More likely, court will find it reasonably necessary in prior existing use. So we want to argue the facts to our advantage and look at the longevity over time, that the longer the duration, the more likely that the courts would be willing to find a prior existing use, because again, these are implied easements and not necessarily in writing, so we would have to find a justification to sway a neutral magistrate. Fourth here on our list, we've got necessity, where we have no access to any sort of public road as a classic example. We look at there might be some sort of possible alternative, but it might be costly. It might require, perhaps in an extreme scenario, using that same example we use in prior existing use, perhaps a helicopter to helicopter over those two parcels and not trespass over the airspace. It's practical, and it wouldn't necessarily be a landlocked parcel. Actually, it would be a landlocked parcel, but it would still be accessible through air. That would be impractical and costly. So a lot of these can overlap. On an essay, we want to talk about all of these different types of negative easements. In the case of necessity, we look for facts such as a grantor conveys a parcel that has no outlet to a highway except over remaining lands of grantor over a land of strangers. So in this case, imagine if over time those three parcels got sold to different entities or persons outside the scope of the family. In this case, there would be no outlet to a highway except over those remaining lands. That's the first element of necessity. Second, we look for an easement is absolutely necessary to prevent the parcel from being landlocked, and the jurisdictions are divided, or if the easement is necessary when costs of creating the new outlet is so prohibitive as to be impractical. Now, third on our list of elements, and they must all be present for us to find an easement by necessity, the parties do not expressly agree to landlock the parcel. If land only has a license, not easement to public road, that's another fact we look at. There was a case for Finn where the license existed for the road, so need for easement, but when unity of title was broken, easement by necessity was formed. Now, when we argue the creation of these implied easements, we look for public policy as one of the many factors that we could use to support our argument. In this case, the law favors free-flowing market rather than placing burdens on property that make it practically impossible to sell. Remember, this is the issue with alienability, that land is a finite commodity. There's only so much of it. We look for, and that's part of the arguments that we would use to create the easement. all of these in blue versus the red for the antithesis of that argument to argue for an absence of an easement. Look for labor, where the law favors rewarding labor. We think about overlapping contract principles like quantum meruit, that is what is just owed. The law favors rewarding labor to those who work, to improve and to create property. We also look at traditional notions of fairness. The law tries to reach a result in every dispute over property that seems most favorable and just in light of all the circumstances. We look at security as another example, where we look at safety and security in one's own property as a public interest right. We look at economic efficiency. We want to maximize the value of property, and the courts will consider the burden on parcel between two or more parties. That the court doesn't like this principle of landlocking, forcing folks to do something extreme, such as get a helicopter to fly over the parcels because of the restriction to use a road in our example. And the law also favors the best and the most productive use of property from a societal standpoint, because again, the finite nature of land. So they're also summarized here, thanks to Professor Morris. Predictability. Property law protects justified expectations. Central function of property law is to determine what parties' actual expectations are and when they are and are not justified. We look at clarity. The more clarity in the law means less litigation. And security, people need to feel like they're safe, as we mentioned. Alienability, the free-flowing market in property rather than placing burdens on property that make it practically impossible to sell. Economic efficiency, the law favors the best and most productive economic use of property from the viewpoint of society as a whole. Labor, the law favors rewarding labor, that is rewarding people who work hard to create or improve property. And fairness, the law tries to reach a result in every dispute over property that seems the most fair or just in light of all the facts and circumstances. So next on our list, we've just finished the 4 types of implied easements. We also look at other forms, like, again, we have to look at whether or not it's a negative easement in another case, where a negative easement is defined as a permanent, irrevocable promise by a neighbor, as like a serving a state burden not to use that property in a way that blocks important pathway to the dominant estate. So we think of classic examples like not blocking light or air. They're sought by persons benefiting by the agreement from the neighbor not to do something on neighbor's own land, like that example of blocking ocean view. So even though we have that property interest of we should be able to do whatever we want with our property, we also have this argument of we should also not restrict the right to enjoyment for others. So another example might be that you can't block access to a sewer line. There are many different examples depending on the jurisdiction. But the issue with this negative easement is it has to be in writing. It has to be signed by the party to be charged. Or if it's not in writing, it might overlap with one of these implied positive easements in a different set of circumstances, like the right to be able to use the road versus the prohibition and the prohibitive nature of a negative easement. So there's that statute of frauds requirement for that the easement must be in writing. We look at the 7 various types of negative easements that overlap with traditional negative easements as well as modern easements. The 4 traditional negative easements: the right to prevent a servient parcel from undermining lateral support of a building on dominant parcel. We think about maybe those crowded cities where buildings rely on adjacent support from another. So if you were to tear down a structure, it could compromise the structural integrity of an adjacent underlying structure. Or it could be the opposite of that. It could also be don't build too close to the building, where you might compromise our building, you might push our building such that the building might no longer be level. This is a problem, and throughout our crowded cities, I'm sure there are numerous examples that you can see in Hawaii as well. Secondly, there is a negative easement and a prohibition on blocking the flow of light on dominant parcel, the flow of light. So you can't build a skyscraper in a residential neighborhood that takes away all light. Blocking flow of air to the dominant parcel, and blocking flow of artificial stream or an aqueduct to dominant parcel or an artificial stream. Now, common law for natural stream, we look at the riparian land doctrine, for example. Running with the land. Now, this is another example. Oh, the modern. So those are our 4 modern, and we've got 4 traditional, and we've got 3 modern examples. That we look for the development of land for environmental purposes, environmental conservation, alteration or destruction of buildings with historical or architectural importance. So, for example, Iolani Palace, or countless examples in Hawaii that we can think of. We can think about dukes. We can think about statues in Hawaii. We can think about the Pali Lookout. That these we want to protect for as long as we can, for history, or for some important architectural purpose. The servient parcel from blocking direct sunlight to solar panels on dominant parcel, another important aspect, especially in the state of Hawaii, where we don't want buildings to block sunlight, especially for those who use solar to generate light. Now, we've got 2 requirements here that fall in line with running with the land, that these have to run with the land. The first, it's got to have some sort of benefit that runs with the servient land, and it's got to have a benefit to run with the dominant land. So both pieces of land were in the example of, you might have a developer who wants to build a skyscraper, but that blocks light for Hawaii homeowners. In that example, both of them would have to be bound by some sort of express writing for this creation of a negative easement. And we'll see that a lot in home purchases when you sign those title forms and those agreements for the easements that are built in. And a lot of times, if you just go to the county office, you can find out if your property is subject to an easement. So that's an easement argument, the easement of pertinent benefit to the person. This is distinguished where the benefit ties in with the person. That is possible, but our general rule is runs with the land, and easement is attached to the dominant parcel of land and runs with the dominant parcel, burdened, benefited parcel. But we do have where we can have it so it benefits to a person. So long as A is alive, A is not allowed to block sunlight for B. If an express easement is created, the burden runs with the servient parcel. If and only if the writing is satisfied by deed or doc that references deed that contains easement, there has to be some sort of intent element. The original grantor created the easement, intended easement to run with the land, and there has to be notice. So the way I remember this is that we need the writing, we need an intent, and we need notice. Notice for subsequent purchasers, we will look for facts and whether or not those subsequent purchasers had notice of the easement when they purchased a servient parcel. So we look at county deed records, for example, and actually we look for a purchaser of the burden parcel and whether there was actual knowledge. We also have constructive knowledge, where you should have known. You can't just say, I didn't know, but it kind of falls along the lines of fiduciary requirements for real estate agents in Hawaii, as well as for property lawyers. So there's the constructive requirement, should have known, because an easement is somewhere in the chain of title. So you have to do your due diligence in home purchases. You want to look at prior purchases and whether or not there was any sort of negative easement tied with the land. And an inquiry, he or she should have asked because there were visible signs of easement, road, telephone, sewage, cable, etc. If you have a property where there might be access to a sewer line on that property that affects other neighbors and other adjacent parcels, then that might fall along the lines of this inquiry aspect, where you should have asked, you should have done your due diligence, you should have investigated. So easement and gross, as we discussed, where we might have a distinguished negative easement that doesn't run with the land, but instead ties with the person, and the person is the entity who runs with the land, so to speak. We call that an easement in gross. Now, generally, we have a presumption against this, since it's suspect. it's automatically suspect for us not to see an easement run with a person, as it may be more difficult to prove that requirement that the easement runs with the land. And so an easement in gross is defined here as an easement granted to a person. If the grantor intended to grant the easement to a person, no dominant parcel, only a servient parcel, burden parcel, but no benefit that parcel. For example, you pick lemons for your whole life. At transfer of lemon owner easement till benefited party dies, generally disfavored. The language must be clear if we are using an easement appurtenant, or I'm sorry, an easement in gross. These are the two types: easement appurtenant, following along the lines of benefit to land; easement in gross with an easement effect tying with a person. So that's the example. It's generally suspect. Now, if you have an implied easement, and if that's created, the burden runs with the servient parcel if not, and doesn't usually apply in constructive trust cases. If it is reasonably necessary to enjoyment of dominant parcel, and there is some sort of intent that the easement run with the land, absolute only for creation. Now, an easement can also, we also want to, when looking at negative easements in general, we also want to look at scope. We also have this issue of the scope of the easement. Each easement has particular scope. We look at the length, the width, the intended purpose. Dominant parcel may not use easement in a manner that exceeds the scope. So if we have a negative easement that only affects the flow of air, for example, we can't use that as some sort of parallel reasoning to support a negative easement for a prohibition against blocking light, absent that writing requirement. So that also falls in line with the elements that we need to prove that writing, the win argument, the writing intent, and notice. So beyond the scope, we can also look for termination of the easement. Usually easements are to last forever unless they are expressly terminated. They may be terminated, however, voluntarily or by a court order for dispute. So here in Hawaii, we might have the First Circuit, and they do this all the time, where they might say that an easement is no longer relevant, especially with shifting modern times. We also have 5 ways to terminate an easement. I like to remember this as REMAF, REMAF: release, expiration, merger, abandonment, and frustration of purpose. So release, of course, like contract law, there's some sort of express writing where they agree to eliminate an easement. Maybe a developer wants to pay out a landowner to block their light, and in exchange for releasing that easement, the homeowner is going to get some sort of annuity or payout, or some sort of other form of compensation. Secondly, we look at expiration. Maybe an easement has term. We don't see it as common in Hawaii, but I'm sure there might be some scenarios that exist in land that says that you may not block light for a certain period of time. Maybe perhaps we anticipate that in 50 years, every single house, every structure will have solar panels, but Hawaii isn't that far there yet, so we might put an issue on, we might put a restriction on time. We look for merger, where the dominant and the servient parcels, it might come under a single owner. So in the example of a developer, skyscraper company, and regular property owners, they might all one day come under the same owner. And in that case, the owner of both parcels can decide to eliminate that easement if it runs with, and if it runs with both those respective pieces of land. Abandonment: owner of an easement by their own conduct indicated intent to abandon the easement. And frustration of purpose: easement has become impossible to use or is obsolete. So in a terrible scenario, you might have it where e-logging pallets might be inundated by water in a catastrophic tsunami, and so in that case, if it's completely destroyed, there might be a prohibition on, of course, raising the structure, but maybe raising the structure might be needed to build a replacement replica, for example. So that is everything about easements. I think lastly, on our discussion on easements, we want to talk about public policy arguments that we can use to argue against the creation of an easement. We can also use those same principles that we talked about for creation of an easement to not allow that easement, like in the example of Iolani Palace being inundated with water. Predictability. Courts want a predictable outcome. Property law protects justified expectations. We want more clarity, less litigation, security, fairness, labor. And a lot of times these negative easements, they are very painful to enforce. They take a lot of time from the court that could be used for other purposes. And so those are our easements, our servitudes enforceable as easements. We've got many other types of servitudes. We also have servitudes as enforceable as a covenant. We already talked about the license, the distinction with a license, which is revocable at will, and these easements, unless you have remath, like some sort of release, or you have some sort of merger, or you have abandonment, frustration of purpose, or you have an expiration, you're likely not going to be able to get out of that. But it's much more easy to, of course, get out of a license, since it's revocable at will by the nature of a license. Now, easements enforceable as a covenant. We define covenant as a promise made in contract that binds not only parties to the contract, but deemed beneficiaries to those contracts. Now, the courts create covenants to get around reluctance to recognize more types of negative easements. Now, the market pushed for more ways to create promises running with the land, and so we've got 3 types of covenants that we can use, and courts should interpret a covenant in a manner consistent with the intent of the original parties to the covenant. So we start with inequitable servitude. Courts will enforce a promise as inequitable servitude if 4 elements are satisfied. Now we start with our first requirement. We look for a covenant that requires all owners of adjacent houses to consent to construction of houses. Construction would not affect property values. Benefit is negligible. Benefit to neighbor through enforcing covenant is far outweighed by hardship enforcement would cause landowner. We don't want to necessarily cause a diminution in value to someone we are trying to have an equitable servitude against. The benefit is negligible because we don't want to create unjust enrichment. And we want to do a balancing test where we look at whether or not we can enforce a covenant and whether that benefit is outweighed by the hardship it might cause. So to allow someone to use a road might be reasonably necessary. So if we can't find any of these examples, we can fall back to a covenant. Now, in this case, we also want to quickly mention the relative hardship doctrine, which permits termination of a covenant if the hardship to burdened estate is larger by considerable magnitude than the benefit to the benefited or dominant estate. We look for a big burden and a small benefit, and if the burden might equal the benefit, the doctrine does not apply, because that burden really has to outweigh the benefit. Within an implied reciprocal negative servitude, we want to look for some sort of developer buying up all the land and severing it into small parcels. General plan or common scheme. I like to think about this as a classic Hawaii condo example, where the developer burdens all smaller parcels with a covenant designed to burden or benefit all those in common schemes. So we look at condo associations, for example, where all houses need to fit a certain mold or design. There are 4 elements to this implied reciprocal negative servitude. We looked at in the beginning that there was some sort of single developer who owned all the parcels, like maybe a real estate developer firm who bought up land, or a U.S. corporation that annexed land and somehow it became legal over time. I still question that. Developer's intent was to create a common scheme or general plan of developer to benefit, and all purchasers of lots within the scope of the development area. All lots were intended to be reciprocally benefited and are burdened by the promise. Reciprocity. A person whom promise is being enforced received notice of promise, like when you move into an HOA, condo association, and you get notice of all these restrictive rules, like you can't put a fence around your pool. I think I saw that on YouTube the other day. That's one example. This can be actual, or it can be oral, or it can be written. It can be constructive, where there's some sort of recorded plat or declaration of restrictions among the common scheme or general plan listing all restrictions, or there are covenants stating that the disputed restrictions included in more than half of the recorded deeds in the development area. So if we've got a set of condos, if that's recorded within at least half, then we're more likely to find an implied reciprocal negative servitude. We also look at that inquiry piece that overlaps with the notice requirement, where we might have actual, we might have constructive, or we might have inquiry. Here, if all the houses are so similar, a reasonable person would have inquired as to whether the subdivision started out as a common scheme, and if more than half the recorded deeds in subdivision describe the common scheme and the restriction at issue. General plan may call for some, but not all, lots in development to be burdened by particular restriction. Developer's intent that a restriction apply to only some of lots does not prevent a court from finding existence of common scheme for implied reciprocal negative servitude purposes. So I like thinking about the condo example and the restrictive condo association issues, which we'll talk about later in the next segment. We also have, yes, we talked about the HOA dues, real covenants as another example. Traditionally, courts will enforce a promise as a real covenant that runs with benefited and burdened parcels if 5 elements are present. Again, we look for writing 3 ways. We look for a deed, a lease, or a declaration. And I like thinking it as DLD, just using like REMAF as we talked about earlier. Transferring the property intent, lease transforming, property interest, and declaration of restrictions filed by developer. Representation in sales or rental literature do not count as writings for covenant. So you might have a marketing material, but it does not fall on the line of a deed, a declaration, or a lease. Some sort of legally binding document. Yes, actual notice. Purchaser actually knew. Constructive notice, where there's a deed, lease, or declaration of restrictions containing the promise that's recorded. Or we look at the inquiry notice. Well, in the case of constructive notice, they should have known because it was in the chain of title. We want to look at the past purchasers and sellers over time and see if they might have had some sort of promise that restricted them. And also inquiry notice, overlapping with what we talked about with negative easements, where you might have it where the experience should have prompted a reasonable purchaser or leasee to inquire about whether covenant burdened the land before he purchased or leased the property, should have asked or inquired if person had means of knowledge due on burden. Now, industry standard as our standard of care. There was a Dixie case where the real estate agent should really know all this stuff. We trust them since they're licensed. And that is a writing requirement. Before we move on to privity, let's talk about notice. Current owner of burdened parcel had notice of restrictions when she purchased it. That notice can be, yes, we talked about the notice. It can be actual, constructive, or inquiry. And we want to look at intent. You need that intent motive. So a lot of this with covenants overlaps with what we talked about with negative easements in writing, which can be an express or implied. These are 4 types of implied positive easements, but you might have some implied negative easement. Usually we want it, so we have that writing requirement for an express easement. But if we have an implied easement, the burden runs with serving parcel, if not usually constructive trust, reasonably necessary to enjoyment of dominant parcel, and intent the easement to run with the land. Let's see. Oh, yes, talked about intent. That yes, original parties to covenant, intend, and promise would run with the land. Now the fourth and the fifth requirements of covenants are kind of tricky. There's a touch and concern element, and then there's privity. Touch and concern. Also with intent. Before we move on to touch and privity, with an intent, the covenant is made to grantor or grantee, and his or her heirs and assigns, or the covenant is intended to bind future owners, or covenant is intended to run with the land. For touch and concern, restriction touches and concerns both benefited and burdened land, or promise intended to benefit burdened land in fact and intent. Requirement is met when promise, such as a non-compete clause, was intended to benefit and burden the land, and legislatively does benefit the current and future owners of dominant estate at expense of serving estate. Benefit and promise affects quality, value, or mode of enjoying the dominant estate. Within the touch and concern element piece, that promise must touch and concern both parcels to be enforced as a covenant. Promise to pay money are typically considered free-floating promises rather than promises that touch and concern land. A promise to pay money isn't necessarily running with the land. It's just a random free-floating promise. We want to look for facts that can show us whether or not it actually runs with the land. And the promise does run with the land, since typically found to touch and concern land because all parcels are benefited by such payments, within this narrow exception for HOA fees for upkeep of shared land. You promise to keep your parcel clean and to rake all your leaves in your condo or maybe in your townhouse, because that benefits the property values of other adjacent neighbors. Endless examples. And sometimes these can get so restrictive that the courts step in to say this is just ridiculous. We'll talk about other illegal aspects of these HOA or associations or co-ops and the distinction there. Very fascinating in our next video. So lastly, before I move on to our next topic before we move on, terminating covenants and the like, we'll talk about really quickly this fifth element of privity. There are two types of privity. There's vertical and there's horizontal privity. Vertical privity usually exists when the burdened land moves on from original promise maker. Grantor of burdened land does not retain any interest in burdened land, must transfer whole interests, or there is no privity. There's also horizontal privity, which is satisfied when both parties with original promise to do something have the legal property interest in burdened parcel. We look at maybe a loaner, the owner or some sort of landlord and tenant relationship. This overlaps with a lot of what we talked about in my tax class. Vertical meaning that we give the property away versus horizontal meaning the fruits. Horizontal privity, or same. In this case, you'll have privity in certain situations, like where the same person owns both parcels and decides to sell lease one of them. If the promise contained by deed or lease burdens one of parcels for benefit of the other. Adverse possession, on the other hand, that defeats privity, which is great. Now, a typical example where privity exists is a strawman structure. The transfer two parcels to strawman, who then imposes a covenant on land, then transfers parcel back after commonality of estate created. They have instantaneous horizontal privity. So we'll talk about this next area. Terminating and modifying covenant. Release doctrine, dominant and servant parcels can terminate a covenant. There's this merger doctrine where automatic termination exists for a covenant if the dominant and servient parcels or estates come under the same person in same moment. Change conditions, where conditions change so drastically that enforcement will be of no substantial benefit to the dominant estate. Change conditions must be so radical that they essentially defeat the essential purposes of covenant or covenants, rendering them valueless to the dominant estate. There's also the abandonment doctrine. Conditions change so drastically such that enforcement will be of no substantial benefit to the dominant estate. Within terminating and modifying covenant, many estates have marketable marketable title statutes. Marketable title statutes automatically terminate restrictive covenants if they are not recorded after a specified time. Some statutes restrict enforceability of covenants and or availability of injunctive relief when an enforceable covenant is violated. Statutes differ from each other. Now, substantially look at each is applied according to its own precise terms. Relative hardship contract, for example. Pay damages and proceeds for loss of air or light. Statutes that states enacted to restrict, terminate covenants. These look for some sort of marketable title statute. Now, the construction would not affect property values. That's another fact that we don't talk about. If this were an essay, permits a court to terminate a covenant if dominant estate long ceased enforcing the covenant, dominant estate has tolerated or failed to object to objections of covenant over a substantial period of time. Kind of relates to acquiescence themes that we talked about within positive implied easements, like constructive trust, where we have that acquiescence aspect. Now, enforcement becomes unreasonable since use of dominant tenant is unreasonable. No longer enforcing prohibition of beer or alcohol sales, for example. Don't need to know. Unclean hands, violated himself, acquiescence, tolerated violation by owner of servant parcels, abandonment, tolerated violation by other parcels. It may come up in the bar. These are actually great. Unclean hands if you violated, or acquiescence, tolerated violation, or abandonment, tolerated violation by other parcels. Common scheme still found even when all parcels are not burdened. And we'll talk about remedies and various different public interest concerns that we can talk about on an essay. Now, a traditional remedy for violation of a real covenant was damages. That traditional remedy was for violation of an equitable servitude, such as an injunction, injunctive relief, to get someone to keep their promise, to make sure that you don't put a fence around your pool. Remedy for violation of a covenant. Modernly, courts have flexibility to remedy violations of covenants any way that does justice. Covenant must be continuously applied to everyone else, or else it is abandoned, as we talked about. Courts prefer damages over injunctive relief, which really should, injunctive relief, as we'll talk about in remedies, really is sort of a last mechanism when no other remedy is available, since courts really try to refrain from forcing or any sort of behavior or forcing the estoppel of such behavior. Now, the only issue of is where justice requires it. Courts generally hesitate to grant injunctive relief only unless justice truly requires it. They will, though, in circumstances where it makes land to go fallow, where if not, It might decrease the property value in surrounding land, since that would not be cool. And no covenant can be sustained if it is inconsistent with the public good. We look for public interest factors that benefit the public and society at large. We look at a reasonable test where grocery stores, proximity, and a covenant prohibition to use as a supermarket might create a food desert. We see that in a lot of places in Oahu, where places in Waianae have historically not had access to healthy grocery stores, and we see that disparity across our island that is unfortunately so prevalent in the 21st century, and hopefully that will change. Public policy covenants, unconstitutional covenants are unenforceable. State action on racially restrictive covenants are unenforceable. We want to think about the Equal Protection Clause. No racist court or public land would enforce a covenant, for example. So that's why we have public policy, where an unconstitutional covenant is generally unenforceable, because even though you have private actors that might say, we don't want a person of a certain race to move into the HOA or into the condo or the co-op, in order to enforce such a clause, that would require a judicial remedy, and courts cannot apply a judicial remedy that violates the Equal Protection Clause. So in that regard, even private actors within housing areas and HOAs, they cannot lawfully discriminate, even though they're not state actors but private actors, because again, the Constitution and our protections apply for state actors and government actors as intended by our founding fathers to withstand tyranny. State action is present where a court actively enforces a racially restrictive covenant, as we talked about, and the court is bringing the full coercive power of government to deny access to property rights. Private property is being actively pressed into operation by government actor. 5 types of restraints on alienation. I like to think about it as DRGAR, D-R-G-A-R, like Daniel, road, and Gar, to live in Hebrew, like Dr. Gar. Covenants, conditional restraints. We look at direct restraints on alienation of fee simple. Courts hate fee simple restrictions, but they'll hold it if they're reasonable, usually. Conditional restraints are sometimes enforceable if they pass these 2 tests that the courts will apply. But the property cannot be alienated unless these conditions are met. First is the total restraint on alienation of a fee simple is generally void, and it's for being unenforceable. If you buy land at fee simple, you should be able to do whatever the hell you want with it, because you bought it at fee simple. Property cannot be alienated. Those are generally unenforceable and void. Now we look at charities. The burden or the risk may defeat the purpose, and in the case of charities, it can be enforceable unless a conditional restraint on alienation of property, other than first right of refusal, unless in validating the restraint is necessary and in the best interest of the charity due to unforeseen circumstances. So I might say, in the classic case of a bequest, where someone decides to allocate their estate upon death to a nonprofit, maybe for the Queen's estate, for example, Ulukalani estate. If something happens where unforeseen circumstances would make it so that if the Queen said, I don't want my house to ever be turned into tourism, then that might be impractical, because now the state can actually benefit from charging fares on that property. That's not a real example, but that's just my own hypothetical. Where the burden or risk might defeat the purpose, especially if that was intended to generate money. When deed categorically forbids sale of fee simple or in covenant, grantee promises to never sell the property. We look for disabling, forbidding the owner from transferring interest in property. Again, that restraint on alienation. Total restraint on transfer of leases are generally enforceable. Now that's a restraint on lease as opposed to actually a total restraint on the fee simple. This is for a non-charity. For non-charity, it's upheld if reasonable. We look for reasonable, and for charity, upheld and enforceable unless best interests of the charity to declare it invalid. Promissory nature, where the grantee promises not to alienate his interest in the property. Total restraints on transfer leases are generally enforceable, as we talked about. Forfeiture, we're forfeiting future interest if owner attempts to transfer her interests in the property. And those are our conditional restraints. And our issue of conditional restraints versus direct restraints, we really don't like total restraints on alienation for fee simple. We might have, we have two different tests depending on whether or not we have a charity or we have a non-charity. We look at reasonability, or in the case of a charity, we look at if invalidating it is in the best interest of the charity. And that is our first half of property review. Next, we'll do a crash course on different types of conveyances, as well as to talk a little bit more about restrictive covenants.